Welcome to Risk Engineers Talk Governance. In this episode, due diligence engineers Richard Robinson and Gaye Francis answer a question they received on the topic of rail safety pressures and the SFAIRP approach. We hope you enjoy their chat. If you do, please give us a rating and subscribe on your favourite podcast platform. If you'd like more information on R2A's work or have any feedback or topic ideas, please head to the website r2a.com.au. Also, there's tickets available to meet them live in Melbourne or online. Details are in the description.
Hi Richard, welcome to another session of our podcast.
Good to be back again.
Today we're going to address one of the questions that we got in our Q&A with R2A, and I'm just going to read the question out that we have, as we've said in our introductory podcast there. A lot of discussion and questions were generated from our previous podcast session 5. So this one came through, and I've been listening to your podcast in pursuit of better understanding risk, due diligence, rail safety, national law and duties of engineers. Some topics are hard to rationalise. For example, the relationship and hierarchy of rail safety national law versus, for example, the Victorian OH Act. Also, what is and isn't required when it comes to due diligence. So that's a pretty open-ended question there that we've got, and there's a number of points that can be covered. So,
well, first of all, we better actually sort of go through the hierarchy question of the legislation. And the OHS Act and the WHS legislation always takes priority. And the Rail Safety National Law is basically a subset. And the Act is quite clear that if there's a conflict between the two, then the WHS, OHS legislation will be superior at precedence. However, there is no double jeopardy. You can only go down once. And chiefly the Rail Safety National Law, and this is one of these interesting things, the way in which they've gone about this. Because we're a federation, we had to harmonise legislation. I mean, when we federated, the states only gave up the minimum powers to achieve get the constitution. So we had appointed a new High Court. We gave up defence to a federal body. We gave up customs and excise to a federal body. But everything else, like, and we meant to standardise railway lines too, which we've been working on for the next 100 years. But anything else, you have to have an intergovernment agreement. And so the Rail Safety National Law was one of those attempts to get intergovernment agreement, the same way we did GST and the model OHS and WHS legislation. Now, there's two ways of getting harmonised legislation. You either have a model act, which everybody says will adopt the model act by each parliament, plus the edits, or you say one parliament passes the act, and then everybody adopts that act as passed by that parliament with edits. And that's the way we did it for Rail Safety National Law. So the South Australian Parliament passed the legislation, and everybody then has an application act where they adopt that legislation with edits. In the case of Victoria, those edits equal the size of the South Australian legislation, which is a little bit sad, but that's another matter.
Whereas some of the other states just changed the name of South Australia to their own state. So
more or less, yes. Now, what the rail safety legislation basically does is adopt the SFAIRP approach. And apart from saying, that the WHS legislation, OHS Act is superior, but there's no double jeopardy. But then our regulators went and did a deal with each other, both the safety regulators and the rail regulators got heads of agreement. So ONSA, which is set up by the Rail Safety
National
Act,
Law,
basically has heads of agreements with all the safety regulators. And they explain that it's all about efficiency. And so presumably if something bad happens, they're going to decide who's going to prosecute.
Yeah.
Now, the next thing that pops up because of the SFAIRP thing, which I don't think we've talked about particularly, which is actually really rather important, you see, once upon a time, and that's why a lot of people would like it to go back to being, if your regulator said what you were doing was okay, you had sign-off. Under the SFAIRP deal, that doesn't happen. The SFAIRP thing says it's an objective test which you have to sort out, and your regulator is more concerned about the process that you've undertaken rather than necessarily the final result. Now, obviously, if they're unhappy with the final result, they're going to start asking you to prove why it's reasonable in the circumstances, but it's still your call in that sense. You want your regulator to be there with you, but if you go wrong and you go down in court, even if the regulator's embarrassed, no skin off their nose per se.
So the regulator's no longer taking any responsibility. So if you deliver your safety case, for example, to the regulator, they're almost just an an interested party that's had a review of it and giving you some feedback.
We see nothing wrong with what you propose.
The classical lawyer question when you ask them, is what I've done okay?
That's correct. Yeah, so it's become really rather complicated. And I have to say, I don't fully understand, because remember, in some jurisdictions, they've kept their Electrical Safety Act. Like Queensland, for example, retained their Electrical Safety Act when they introduced the Work Health and Safety legislation. And they basically say that when you're dealing with electrical matters, you still have to do SFAIRP and so forth, but that falls under the Electrical Safety Act. And so now you've got this sort of competing hierarchy, like it's Marine Safety National Law is another one, where the WHS legislation has moved into Marine Safety National Law, but that's obviously in a different domain again.
Yeah.
And so you've got all these sort of interesting legislative frameworks, although so far as we can tell, and again, this becomes a very legal question, because as we have commented in other places, planning law, for example, doesn't seem to really respond to the WHS Act, whereas we were under the impression from what we've been told by various legal counsel, the WHS is a governance document and it's meant to take precedence.
Yeah.
So,
and I think it depends on, which court you're in, doesn't it? As we said, but I think the planning one we might leave to another podcast.
And treated very delicately too.
Very, very carefully discussion, very careful discussion. I guess what the regulators are using it for is if they're not signing off or approving the safety cases, but they're almost using it as a license to trade it as a competency type exercise.
I think that's probably right.
So we've had that discussion before about your safety case argument is and the relationship with the regulator is almost a license to trade approval process.
Yes, you've demonstrated in the governor's sense that you're competent to do the business. Whether you're actually making individual decisions properly, not their call. Unless you obviously got something patently daft.
Yeah.
But when you're talking about, you will have already met the standard. That's not the argument. The question is how much better than the standard was reasonable in the circumstances.
I think the regulator also has a role because they are getting all of those safety cases in and having a look through. You can get an idea of where the industry is as a whole, and there's sort of benchmarking across the industry of what organisations are doing.
Well, it's a bit like the Powerline Bushfire Safety Task Force, which we were both sort of members of, and you followed up I mean, that introduced new controls, which therefore became recognised good practice, at least in Victoria, and all the other jurisdictions then sort of started looking and going, ooh, should we be doing that? And there's reasons why they may not. For example, if you're further north, you get more humidity, so you just don't get the dry conditions you get in Southeast Australia. But you've got to think it through and you've got to have your arguments.
And I think that leads on to that last bit of that question, what is and isn't required when it comes to diligence. I think the diligence or the due diligence approach is really the governance approach and the process that you go through to come up with the argument and your position of where you are in terms of safety.
Well, that's what those lawyers were telling us when they first introduced the WHS legislation. It was a governance act, and it was intended that if you weren't able to comply with this act, it was intended you shouldn't be business. That's what the stated, we were just told, was the stated purpose of legislation. And I don't think we've seen anything to change that position, have we?
No, I agree. And as we've said before, it's about the control. It's what you can do in the situation, what is reasonably practical that you can do. I always tell our clients that it's more important to document why you're not going to do something, that you've considered a particular course of action and you're not going to do it, and these are the reasons why. But it's something that you've got to continue to revisit, and it's about having that governance processes in place. Make sure you've got the right stakeholders that you're engaging with. Make sure you've got a robust process that you undertake, and make sure it's documented, but don't do it and put it on the shelf for 10 years.
Correct. Because
the goalposts change. And so you've got to make this is a living document. This is a living process that has to be revisited on, a regular occasion or when circumstances change.
That's right. And that's one of the reasons why you redo your safety case. And how often do you do it? Obviously, it depends on how rapidly things change in your environment. But if new technologies emerge, then you should be considering them.
Yeah. So I think what we tried to capture today was one of the Q&As that we had from our listeners, and we appreciate any of those. So if you've got any questions, please shoot them through. But it's not simple. There's SFAIRP pressures coming from all different ways. There's different legislation. The rail safety and the WHS or OHS legislation aligns pretty well. but there's other legislation that it's not as coupled as that.
Correct.
There's your different stakeholders involved, and you're getting pressures from commercial pressures, regulatory pressures, environmental pressures. So there's a whole...
Legal liability pressures. I mean, one of the things we always point out is you really need your lawyers and your designers to align. If they're not aligning, then for the life of me don't understand how you've demonstrated due diligence in a way that would satisfy your directors' obligations under these acts.
So again, cooperative process rather than competitive process.
Yes.
But the due diligence process and governance process that we sort of undertake will get you out of that hole.
Yeah, and it's not actually that complicated. That's the other thing. Maybe we do it so often, but to us, it's actually relatively straightforward. Where you get stuck is if you start following a standard which says do it this way, and you just miss the process because it does require thinking.
It does require thinking, absolutely, yes. and that clear thinking, not just thinking.
I hope that's what I intended, Gaye.
I hope so too, Richard. So I think on that note, we might wrap this podcast. So thank you for joining us again, and I hope you listen next time.
Thank you.